What's up, everybody? We have an interesting discussion to have today. Before we get to this hearing, I wanted to mention a few things off the top as to where we are, where we're going. People were asking where the Melly video was yesterday. It's just been crazy. So many things going on, work, YouTube, and otherwise. So I did not have time to do a Melly video yesterday. Also, I expected, and I was wrong, that we would get a Scott Peterson verdict yesterday. So I wanted to focus on that and do a video on that. So I'm thinking we'll get one today, but who the heck knows, right? There were some jury questions. I did a short that's going to be posting on YouTube, TikTok, Instagram, Twitter. You can follow me at Tragos Law. I don't know why my handle is not showing up on here. That's weird. At Tragos Law is the handle on all those social media sites. So there we go. There it is. And we will post a short talking about the jury questions, who it's good for, who it's bad for, the amount of time that it's taking. Once the Scott Peterson verdict is done, we'll get back into Melly, provide an update, recap, and continue forward with that. Yeah, only 3,000 more subscribers to 250K. So hit that subscribe button if you haven't already. Hit that like button. We also have our first product that we're working with that people sent me to use and kind of review and talk about. And it's pretty awesome. So that's coming in the middle of the video. We'll talk about that a little bit more. So I just want to keep everybody up to date with things that are going on, what we're planning. We are also planning the members only live for June on Friday. So make sure you are, if you're a member, you've got that turned on so you can get that alert. I think what we're going to do there is we'll do a Q&A as always, because you guys like the kind of non-law Q&A stuff. But also, I am going to solicit the members to help me figure out what type of celebration and giveaway we are going to do for 250K, which I'm hoping and praying is going to happen in July, which is really cool. So I appreciate everybody joining us for the video. We are going to get to this Kohberger hearing. I have not watched it yet, as I like to watch it for the first time with you, and you get my immediate reactions. I have heard they talk about cameras and stuff, but I thought it was just a motion to compel discovery type hearing. So I wanted to wait, react genuinely in an authentic way with you, as if I was sitting in the courtroom listening to it for the first time. So we are going to, I don't know what time Friday yet, so just keep an eye out. So we are going to watch this together. Get your questions in the chat, of course, like always, so that we can make sure we answer them. I will stop the video kind of throughout, pause it, answer your questions, like we always do on this channel. Thanks for everybody that is always along for the ride. A lot of people had stuff to say about the short that we clipped out yesterday about how I think it would be beneficial for us as the public to kind of talk about this stuff and watch this stuff. Some people liked it, some people didn't, which I understand and you got to expect. And I was not thinking about any one person. I was not calling out anybody specifically, but just generally thinking, as hopefully all of us, whether we think the state's got a strong case or not have a strong case or whatever it may be, we can have these open discussions, which I think is a positive thing for our judicial system. And keeping everybody honest is always a good thing. Honesty is the best policy, right? All right, so let's take a listen to this hearing together. Some new members coming in, which is always awesome right before the live.
All rise. Thank you very much. Please be seated. Good afternoon, everybody. Okay, let's get on the record, please. Okay, we're on the record. This is State of Idaho versus Brian Kohberger, case number CR 29222805. Mr. Kohberger is in the court. He is represented by Ms. Taylor, Mr. Logston, and Ms. Nasseth. The state is represented by Mr. Thompson and Ms. Dennings, also Mr. Nye and Ms. Beatty. And we're here for some motions, discussions. And before we get there, I want to address really everybody, about the revised amended dissemination order. Apparently there's some misunderstanding about who it applies to and who it doesn't apply to. Because what I thought, and this is 100% my responsibility, I use the term agents, and the revised order says that the prosecuting attorneys, defense attorneys, any agents of the prosecuting attorneys and defense attorneys are affected by this order. Apparently, some of the media interpreted that as it doesn't apply to law enforcement, but it does. So law enforcement they are agents of the prosecuting attorneys. Now, I'm going to issue another another revised order, just to make sure that that is clear, because people seem to be very confused about that.
So anytime you change language or amend something or revise something, anything that seems a little bit different, people are going to try to look at and see how they can, use to their advantage. And not to the fault of anybody. If that's how a rule is written, you should act accordingly and follow the revised rule, not whatever the rule said before. I think they're trying to reach. It's pretty obvious that law enforcement working on the case are agents of the prosecuting attorneys. But in an abundance of caution, the judge is going to amend that non-dissemination order and I guess add in law enforcement language and even make it more specific, which I appreciate about this judge. And the last judge really didn't do that. She was just kind of like, it's good enough as it is. This judge, on the other hand, is saying, I think it's good enough, but in an abundance of caution, I'll add in the verbiage of law enforcement. So there's no confusion that law enforcement, in fact, is included in this non-dissemination order.
Agent, definition of an agent is one that acts or has the power or authority to act. Another definition is one empowered to act for or represent another. So I'm going to include law enforcement for the prosecuting attorneys, agents, and for the defense attorneys, investigators. So it's clear. I think it's sort of doubling down on the definition, but apparently that's necessary. I'm also going to add retained expert witnesses for each side because we don't want to have a trial in the media or in the public. We want it to be in the courtroom. Speaking of that, a comment on the cameras. They're in the courtroom now. And I have deferred my decision about cameras. One of the things that's going to be really important, that is very important, is that the people with the camera and media need to follow the rules. And we've had some issues where people were pushing the envelope, particularly focusing on the tables where counsel sits. You are not to turn your cameras toward the top of those tables. And if you do that, you're probably going to have to leave the courtroom. Also, one of the things that happened in the Daybell case is that the cameras just continue to focus on the defendant. Don't do that. That's what brought the cameras to have to leave the courtroom in that case. And what I would prefer, if you want to continue to have cameras in this courtroom, is to back off and not. We have that. Make sure that's muted.
All right, closed captions are on. Sorry. So no surprise that he is referencing Vallow and Daybell, or Vallow Daybell, because same state, obviously, similar decision. Boyce let it ride throughout the entire pre-trial process and then cut off cameras basically at the end. He had plenty of ammunition to do so because of what the cameras did. So this judge is warning them again, do not be like those cameras. Immediately, the first time any of this was brought up, I said, they are going to compare it to Vallow Daybell. That is not some amazing revelation that I had or some great looking into the future that I was able to tell the future. No, this is what every court does. This is what every judge does. So it's no surprise that he's comparing it to Lori Vallow Daybell and telling the cameras not to do what the cameras did in that case. Additionally, pushing the envelope, cameras trying to get certain things that maybe they shouldn't get. There are two other trials we have watched together on YouTube where this has been an issue. Number one was Gwyneth Paltrow, if anybody was here for that trial. There were all sorts of issues that her lawyer kept objecting to because they wanted to focus on her as the star of the show when they were supposed to be focusing on only on who was speaking. And then YNW Melly, where the high sensitivity mics and cameras were picking up things that they should not have, including potentially privileged, confidential conversations between a defendant and his lawyer. They are not entitled to that, by the way. We are not. The public and the media, they are not entitled to high sensitivity microphones and cameras. You're allowed to go sit in the courtroom and watch and hear what you can see and hear. Not as invasive as some of the cameras and microphones can be with today's technology.
Make sure that we just have the totality of what is happening in the court and not just focus, for example, on Mr. Kohberger's face. So that was what happened in that case, and it's not appropriate. One other reminder to counsel to speak, and this is to myself, to speak into the microphone so we can have a good record. All right, I think those are my general announcements or cautions, and I think we've sort of boiled things down to some issues on motion to compel discovery. Some of those issues have been resolved, some have not.
So we have boiled down some issues on discovery. Some of the issues have been resolved, some have not. So that indicates that the state and the defense are working together. They're either agreeing that certain things are discoverable, certain things aren't. And in my experience, most of the time, if it's going to be resolved without a judge stepping in, that's the state saying, yes, we will give you this that we didn't give you before, or that we objected to before, or that we didn't have before. We will give you that. It's very rarely the defense saying, you know what? You're right. That's probably not discoverable. That very rarely happens unless a judge tells the defense that is not discoverable. You're not getting it. So I would think that this means the state has produced more documents and discovery to the defense. Let's get a couple questions here. Jeff H. So are the lawyers smiling so big because of their hourly rate? And is Brian not smiling because of his fate? Hey, made a rhyme. They're public defenders, so I don't think they're smiling like their hourly rate like a private lawyer might. And some people have said Brian is smiling. Some people say he's not, clenching his jaw, whatever. I don't know what any of it means. The point is, he's just a guy coming in the courtroom in probably the worst situation anybody could ever be in, whether he did it or not. So I don't take too much off of that. Kate, have you heard the challenges YouTuber Harsh Reality addressed to you about the BK case? I have not. It seems he values your thoughts. That's awesome. He mentions you quite a lot. That's awesome. I appreciate that. I have seen some of his stuff. I have not seen him throw any challenges to me, but hey, I appreciate that. Vicky, this is where I noticed Law and Crime Network kept zooming in on KC when I watched last night. Summer Golden. Peter, I think you mean KC. KB? Kohberger? I don't know who KC is unless I'm missing it. Thank you for being the best teacher of law. If charges are dropped for BK, found not guilty, the state is protected from a lawsuit, right? Yes. They definitely have enough evidence produced by law enforcement to have a good faith belief to file these charges, and multiple judges now have found that there is probable cause to move forward. So if judges are also agreeing with the state that there's enough to move forward and all the burdens that they've had to meet at this point, they shouldn't and couldn't be sued. There is a prosecutorial protection there. Tori, and if you think about it, Tori, I'll get your question in a second. If you think about it, that's what we want as a society. We want the state to file charges and go after the bad guy and try to get the bad guy. And if they're wrong and you can sue them, they're going to be a lot less likely to go pursue justice for your case or my case or whoever the victim may be, because they may be scared of getting sued now. We don't really want that. We want them to do their job and do the best job, which is why we have these checks and balances and burdens, and why we have judges that have to confirm, okay, this is good, you can go forward, why we provide defense attorneys, why juries are unbiased people in the community that make the final decision. We have a lot of checks and balances in place. It's not always perfect, but this is why they just can't be sued every time they're wrong. Tori, Peter, I missed the video. What is the overall decision about the cameras during trial? It is the judge's reserving ruling. So which means he's leaving it as it is right now, which is cameras are allowed, but he reserves the right to remove them at any point. Very similar to what Boyce did throughout the Vallow Daybell case. Happy HAF. How much are memberships? There are multiple levels, and all that's changing July 1. I think they're like $3, $5, $10, $25 or something starting July 1. Right now, they're $3 and $5, something like that. I'm not positive, to be honest. Catherine, did you catch the cameras picking up the information in Corey Richens' conversation with her counsel or snippets of the jury from Scott Peterson's so many sloppy moments? And this is what we want to avoid. I did not catch it in either of these instances, but I did catch it in the Melly case where I could hear him and his lawyer talking. So I believe you. I didn't catch it in those hearings, but it's been a problem, and courts are keen to it and don't want that to happen.
So let me go to you, Ms. Taylor, to start off. Where do we start?
Your Honor, we would request that we start on defendant's motion to compel and second motion to compel. I believe the third motion to compel will be heard on a different date.
True.
As it relates to the two motions to compel, and I'll present my arguments whenever the court's ready, but I can direct the court exactly to the numbers in those motions to compel that are still up for discussion today and requested for the court.
Excellent. I'm ready.
On the original motion to compel, we are only seeking the court to order number 6 be complied with in that particular motion.
Okay, let me take a look at that. Number 6. And so this is the motion to compel discovery that was filed on May 4th.
Yes, Your Honor, that's correct.
Number 6. And that is request number 160.
That is for request number 160, and that was in the second supplemental discovery request.
Okay, thank you. All right. Yeah, we're getting. Is that me? Okay. Number 6.
Number 6 on that one, yes. On the second motion to compel, Your Honor, we are needing the court to order on request number 1, number 4, number 5, and I think that we have a plan for the other numbers, so it does give us a need for it.
Thank you. Let me make sure. Page. Okay, number 1 is request 1. Or it's request 23.
I'm sorry, Your Honor, it's number 2, request 4.
Okay, I apologize. Number 2.
And it can get confusing when you have first set, second amended set, third set, numbers 1, 2, and 3 in the first set, numbers 4, 5, and 6 in the third set. You know, it can get confusing. So
Request. Okay. And you said number 5.
And number 5, which is request 109.
Thank you. All right. And that's the second motion to compel discovery.
Correct.
All right. You want to make an argument about those?
I would love to.
Okay, go ahead.
Thank you. Your Honor, first, I want to start with talking about the discovery process. As the court knows, we have been representing Mr. Kohberger since the very end of December of 2022. And during the course of the last several months, there has been a lot of discovery that's been requested and a lot that's been supplied. I come here asking the court to compel discovery. I'm seeking an order directing that we receive this discovery. I'm not seeking any other kind of sanction. I don't come here saying that the prosecutor has done something wrong. I come here saying that there are things that we have a disagreement about whether I should get them or when I should get them. And
So already, right off the jump, the beginning comments that she makes, I think, and I don't mean for the cameras, like they're performing for the cameras. I think she wants the cameras to know. I'm not asking anybody to sanction the prosecutor, take their bar license, fine them, anything like that. We have a discovery dispute, and there's all sorts of things being said online, like the state is hiding. Here's the problem, though. One of the Logston's last document did say the state is hiding their entire case. So there is some verbiage and reason. I don't want to just condemn everybody in the media talking about this stuff, because there are things in the documents that make it seem like one side is accusing the other. But I like how Ms. Taylor in the beginning says, listen, first off, the only sanction I'm looking for is for them to give us the discovery, because a sanction is anything the judge does to the other side to force them to do what needs to be done and tell them what they are trying to do is wrong. That's the, quote unquote sanction. But she wants to start off the jump to be like, I'm not accusing anybody of any wrongdoing or misconduct or asking for, fines or anything like that. We just have a disagreement as to what's admissible, which every set of lawyers has in every case. So it should not be a surprise.
secret court order to assist us in this regard. Yesterday, we filed an exhibit that related to our motions to compel, and the purpose of that exhibit was to show the court how the discovery is coming in and what we are weeding through to try to find the information, and to let the court know that our office is making extraordinary efforts. Mr. Kohberger's team works nonstop, and when we ask for discovery, it's because we have reason to believe it exists. So I wanted the court of counsel to be aware it's not a fishing expedition. These are real items that are really necessary to investigate this case and prepare Mr. Kohberger's defense. So with that as the background and the frequent communication with the prosecutor's office to try to obtain the materials we need, we have come to an impasse in a few areas, and that's what brings us to court today. As the court knows, discovery is governed by statute 1309 and Idaho Criminal Rule 16. The purpose of discovery is really to prevent an unfair trial, to prevent trial by surprise.
So I see some people commenting about how the camera's zooming in on Kohberger and the defense team. The judge did just tell them the camera is here to get an idea of what's going on in the entire courtroom. Now, again, if we're trying to take this back to the public interest and what we'd be able to do if we were sitting in the courtroom, we'd be seeing everything, but we could just look at Kohberger. So once in a while, I would say don't. I would say if I was running Law and Crime or whoever's running the pooled feed, I would say let's just get the whole courtroom in an abundance of caution. You can see Kohberger, you can see the judge, you can see the prosecutor, defense attorney, but the zooming in stuff is a little bit, toeing the line maybe.
And also to protect a charged person's rights to meet their defense. It protects their Sixth Amendment rights to have a sufficient and a prepared counsel, I should say, as we have a duty to investigate the case. So in preparing our case for Mr. Kohberger, we've asked for several things that we still need. I'll talk first about request number 6 in the first motion to compel, and that stems from discovery request 160. It's training records. These are training records of 3 specific police officers. Your Honor, we have not asked for training records for every officer that has had anything to do with the case. I would not want to stand here and let the court think that this is an exhaustive list of the officers that we might need training records for. But these are 3 officers that we've requested it for, and the state has indicated they're not willing to give us the training records. These 3 officers are officers that have each conducted critical interviews with critical witnesses in the case, made decisions about the interviews, made decisions about evidence, and conducted other kinds of investigations. We seek their training records to understand their processes. The training records, Your Honor, they are records that we've been able to obtain from various police agencies in the past. In this circumstance, they're not records that I can find on my own. These are not things that are on the internet. They're not going to just hand them over to me. The 2 of the officers that we've requested them about are Idaho State police officers. I have often received training records for Idaho State police officers in the preparation of other cases during the course of my career. They are imperative for us to understand.
It's always important to let the judge know. In all the other cases I handle, Judge, I get these, or a lot of the other cases I handle, I get these, Judge. Also, you can't just ask for every single officer's training. So they're being specific. These 3 officers for now, Judge, but leaving the door open for more later because you don't want to pigeonhole yourself. So everything here just makes sense, and it's going to have to be a judge's call if the 2 sides disagree.
Understand the specialty in interrogating and interviewing people, and for making the decisions that they make with regard to things taken as evidence in the case or things followed up on or not followed up on. That is the purpose for those records, and we're asking the court to order the state to provide the training records for those 3 officers. Moving on then to our second motion to compel, and what we are looking for is a lot of information from the FBI CAST team, as well as the FBI forensic examiner team. What we're talking about here is the CAST team are the FBI examiners that use cell phone records to provide a lot of information that found its way into the probable cause affidavit that the state relied on in arresting Mr. Kohberger.
That alone makes it material, that it was relied on in the probable cause affidavit.
I had the opportunity to meet with the prosecutor, and they indicate that we will be getting those items in number 1 and number 6 disclosed to us, but we don't know when. So I'm asking this court to issue an order with a date certain to obtain those records. These are bits of investigation that the FBI conducted that relate to Mr. Kohberger's cell phone, and the state has relied on that in their affidavit to say that Mr. Kohberger was in certain places at certain times. So these are bits of information and analysis that's been done since December. We are now at the end of June. We do not have those records yet, Your Honor. They are something that's been relied upon by the state for the PC affidavit to arrest Mr. Kohberger, as well as to obtain a variety of search warrants. It's information that the state has agreed we should have, so we ask the court for an order with a deadline to get that.
So that's also not uncommon, right? They've agreed, okay, you're entitled to this, but we still don't have it. And the defense is like, well, we need it. And we need it with a deadline. We've got speedy trial time periods running here. We need this to happen. I also think it's interesting they didn't talk about the stay. I don't think they're going to talk about the stay for the grand jury proceeding. So maybe they've made some agreement there. Unsolved cases and news. Welcome. Patty D, is it a bad sign, the Scott Peterson verdict? Check out the short that's going to drop right after this video. Belinda, the decision to have cameras is a very fine line between public interest and a reality show. Hard for a judge to enforce. Let's hope he can. We've seen a lot of judges enforce it in good ways. So he's got some precedent to look at and rely on. So hopefully that's what he does. And hopefully the cameras respect the rules and do the right thing. And then everybody can kind of partake the way that they should. CH, question, Peter, do you think both sides are suggesting the FBI is withholding the information? I don't think that's the case. It could be, but I don't think that's the case. Sometimes it just takes time to produce this stuff. And if there was no speedy trial, it would be a lot less contentious and a lot less rushed and a lot less asking for deadlines. But sometimes this happens in cases, and it is frustrating how long anything takes in the judicial process. Madam Morbid, Ann Taylor appears to be extremely thorough and knowledgeable. The prosecution better be ready to play hardball. This isn't going to be an easy case. So I'll just tell you, this is not the first time they've seen her or had cases against her. So they will be ready. They understand how this works. I think she seems like a good lawyer as well. I think there's going to be good lawyering on both sides, which is fine. And the facts and the truth should prevail. Emily, are all her issues legit, or is she using spaghetti against the wall tactic? No. See, here's the thing about discovery. The judge may not even say you're entitled to this or that. He may just set a deadline, which is what she's asking for in this case. Or if he's saying you're entitled to it for discovery, that is not the same thing as saying we're going to be able to use it at trial, or here you go, here's your smoking gun, you're going to win the case. Discovery is a very broad term of what you're allowed to see, look at, and what's included in discovery. So really, it errs on the side of, yeah, you can have that for discovery, but you have to see whether or not it is actually relevant and reliable. For the love of God, thank you for the super sticker. All right, we are going to hit our first ad, I think, ever here. So if you guys, let me know what you think about it at the end, and we can talk about it either at the end of this video or maybe the members only live about what's cool about this stuff that they've sent me so far. So, and if you're interested in it, there's also a discount code, obviously, with all of these things. So let me know what you think. What's up, everybody? You probably know that there are a ton of body hair trimmers on the market right now. So when Manscaped sent me the Lawnmower 4.0, my first question was, what makes this different? And then I used it. And there are some major upgrades I did not know about. First, it is fully waterproof, so you can use it in the shower or clean it immediately after use, because we all know how disgusting some of these body hair trimmers can get, all clogged up with hair. Second, there is a light on the razor, which is great for trying to reach hard to see areas, and also great because if I want to buzz early in the morning or late at night, I don't even have to turn the light on and wake up my wife, because there is a light on the razor itself. And lastly, the size. It is the perfect size. And get your mind out of the gutter. I'm talking about the razor. It's not too big or bulky to travel with or to leave on your counter charging wirelessly, I may add, but it's also not too small and dinky and easy to drop when you may be buzzing a delicate area. They also have a brand new beard trimmer I haven't used yet, but I am very interested in. So either of these products or anything on their site, if you're interested, you can use my promo code LAW20, LAW20 for 20% off anything site-wide on manscaped.com. So check it out and let me know what you buy and how you like it. All right. So that was that. And in case you can't tell, I have to use all sorts of stuff to keep myself in order because, you know, it can get wild. The beard trimmer is the next thing on my list. So we'll see what you guys think. If anybody goes and grabs something, let me know, and let me know how you like it as well. All right, let's get back to the hearing here as she is moving on to her next point in the motion to compel.
I want the court to know, I don't think that Mr. Thompson or Ms. Jennings are trying to withhold this. I think they'll give it to me when they have it, but I think an order from the court saying this is the date certain may help them get the information a little bit more rapidly. I'll move on to our last request, and that's number 2 in the second motion to compel, request number 4. And that has to do with the FBI forensic examiner that told the state to look for a white Hyundai Elantra. This is the examiner that originally there were certain years looked for, and that year range was expanded. I believe I have the communications between the police department and the FBI about how that date range changed, but what I don't have is the report from the examiner. I did receive the CD, curriculum vitae, from about the examiner late yesterday from the prosecutor's office. So I'm asking the court to order a deadline for the report to be given to the defense. Again, the court's read the probable cause affidavit that led to Mr. Kohberger's arrest, and the court can see that this vehicle identification was heavily relied on by the state to arrest Mr. Kohberger, as well as to obtain a lot of other search warrants. This is information that is very necessary for us to prepare our case. I don't think Mr. Thompson and Ms. Jennings are withholding anything. I think they don't have it, but I think we need a court order with a deadline so that we can get that. As the court is aware, the state has a duty to provide discovery to the defense. As the court is aware that not producing discovery, especially when it's material, can be a due process violation. And as the court is aware, the state has filed its notice of intent to seek death against Mr. Kohberger. These are critical, relevant materials, all of them, including the police training records. They're necessary for us to prepare and present our defense of Mr. Kohberger. They're necessary for us to do our investigation. They're necessary for us to prepare our case and our motion practice moving forward. These are things that we need to have. There is a high.
So all of this is language that puts pressure on the judge to make sure he's protecting the Sixth Amendment rights of the criminal defendant. These things that we are asking for are not superfluous. These are necessary. We need these to prepare our defense. We need these to investigate the case. We need this to provide Brian Kohberger with competent counsel. So everything she is saying right now to explain why they need the documents they are trying to compel is language that should push the judge to make a decision and err on the side of, again, protecting his rights. We've already seen a situation dealing with the media and Shannon Gray where the judge has weighed the Sixth Amendment trial rights above other constitutional rights like the First Amendment. So she's, again, asking for that in this situation.
Standards now that the state's filed a notice of intent to seek death, and these are very relevant, critical bits of information. They are discoverable, and we're asking the court to order that they be supplied to us.
Mr. Thompson or Ms. Jennings?
So Ms. Taylor's correct. She has everything that the state has in our possession, and we have worked diligently and consistently.
So again, what can a judge do, right? She has everything the state has. The judge can't force the state to turn over something that they don't have, right? Answer is yes, but the judge can say, if it's not turned over to the defense by July 1st or whatever, then you can't use it at trial. You can't continue to accept things you're not giving to the state and then say, oh, well, we got it later, and it's still be used as evidence at trial. So the judge can set discovery cutoff dates, and he can force the state to turn over things that they have, even if they've objected to them. But if the state says we don't have them, the judge obviously can't say, well, you have to turn them over, right? You have to have something before you can turn it over.
And getting her all the information that we have in a quick fashion. To date, we have discovered approximately about 13,000 pages of reports, 13,000 photographs, over 10,000 tips, and over 51 terabytes of audio and video information.
They keep making this argument like we've provided so much, Judge, 51 terabytes. I've heard that 1,000 times, 13,000 photographs, documents. We get it. Nobody's saying you haven't provided a lot. But what the defense is saying is within all of that stuff you've provided is not very specific things that we are asking for. That would be like you asking me for all the cards in the deck and me saying, I gave you 40 cards. It's like, yeah, but that's not all the cards in a deck of cards. So even though you provided a lot of cards, that's not everything I need. That's not everything I've asked for. And I'm entitled to all the cards in the deck, not just a lot of cards in the deck.
So we are down to just a few points of disagreement.
Sorry, Mike.
Oh, is it okay if I?
Yes, yeah, that's fine, thank you.
First, with regard to item number 6 on the defendant's first motion to compel discovery. This involves training records of a couple of officers. Again, these are officers who the state would argue are not material to the case. They've interviewed other witnesses. They wouldn't even be called by the state to testify at trial. And the state objects to this because training records of specified officers aren't included within Rule 16. And they haven't proffered any reason as to why this would be needed for the preparation of their case. Again, these are investigators who have gone out and just interviewed some witnesses within the case. So we'd ask that you rule that this is outside Rule 16. I would just remind the court that several hundred investigators have been involved in this case. Our concern with allowing training records for these few, which we can't understand why there's a substantial need for these particular ones.
So again, the state's saying, well, there are so many officers involved. And the defense has already answered that argument. We're asking for these 3 specific officers right now. I also see a lot of people in the chat saying, I think the state's being unreasonable. I think they should turn them over. And then other people saying the defense gets everything that's necessary, but not everything they want. And I agree with that. And that is why we have a judge. Judge is going to judge in this case and make some decisions. Welcome to Derma and Eric, new members.
Wouldn't open the door to us then having to go and obtain training records for these hundreds of investigating officers who've been involved, some of which are outside of our control.
And she also said, if we give them these, it's just going to open up the door for us to have to go get all the other ones. If I was the judge, that's an easy, no, it's not. The defense is going to have to explain and give me a reasonable basis as to why they need the training records of every single officer they asked for. Right now, they've asked for 3. They've given a reasonable basis that they need them for their investigation. And now every time they add 2, it's going to be harder because it's like, well, you did this investigation, you only needed 3. Now you need 5 more. You need to explain to me why you need those 5 more. And if they can explain why they need them, then they could be potentially relevant. That's what discovery is.
Moving on to the second motion to compel. As to item number 1, regarding cast information. Ms. Taylor has everything that we have. I've also, that includes reports from MPD officers. What she is seeking is a specific report from the FBI cast team, which I had indicated to her is in its final stages of review. And we are anticipating receiving sooner rather than later. And as soon as we do, we will send that over.
Sooner than later.
Well, I don't have a date certain, but within the next few weeks.
I think Ms. Taylor wants a date.
I don't have
If
a
I'm
date.
not mistaken.
I've asked for a date, but that is not how the federal bureaucracy works.
That's, how about we say something like July 14th, unless there's some reason that they can't get that to you.
So I like that from the judge. So let's say July 14th, and unless there's some good reason they can't get it to you. So there is a date. It's the judge's courtroom, and he can force the FBI to give it to you, kind of, unless, again, they have a legitimate reason why they can't. Welcome Shelley and Patricia as well. So the judge is doing what he's supposed to do. You guys have agreed to turn this over, but we can't just hold it open in perpetuity. It better be there by July 14th, which is 3 weeks, which should be plenty of time to get something you're both agreeing that you need to turn over. The defense is entitled to it.
Objection.
Ms. Taylor?
Yes, Your Honor. And then the state has substantially complied with request number 4, which is the same types of information, but related to the identification of the vehicle. Would ask for the exact same date certain of July 14th, only to obtain, if there is one, a potential report that's outstanding.
acceptable, Ms. Taylor?
Yes, Your Honor.
Again, I mean, if there's some itch in that, I mean, we can slow that and see what we can fix here.
Nothing for
Okay.
that takes care of everything.
Thank you, Ms. Jennings. Anything to respond to, Ms. Taylor?
Yes, Your Honor. I want to go a little bit more on the police training records. I am aware that over 120 officers were involved in the investigation in this case. I am not asking for all 120 officers. I will tell the court that likely there are other officers training records that I would want. This is within Idaho Criminal Rule 16. These are records, documents, and objects that may have information relevant to Mr. Kohberger's investigation and defense. These are records that are likely of witnesses. Whether or not the state calls them, they are likely to be witnesses. The three that I'm asking for now, they have critical roles at various stages. One of the officers did a Stillman search for 2011 to 2013, and they allowed trace to get to the FBI to look through this. One of them, that same officer assisted in a search for this same officer interviewed witnesses from the scene of 1122 King Road on the 13th of November. This officer did follow up with some of the key witnesses in the case. This officer signed an Ada County lab agreement, and this officer handled and collected evidence. The second officer that I seek the information from did an interview with a key witness that's expected to testify when this case goes to trial. This officer also mentioned a specialty of working with victims and trauma victims. I think those training records are very relevant. The interview of this key witness was one of multiple interviews of this same key witness by various law enforcement officers. There's a lot of information in the various interviews that's going to come into trial. This officer may well be subpoenaed by the defense to come to trial. That person's training records are very relevant.
So again, she gives very specific reasons here why she needs these specific officers. And the fact that the state might not call them, she just said there at the end, they may be subpoenaed by the defense. We may call them, Judge. They held key roles. They interviewed key witnesses. Tori, why do they review evidence? Why do they have to review evidence before turning it over? So sometimes things have nothing to do with this case. Sometimes there are social security numbers that need to be redacted. Sometimes there are notes between people that might be privileged. So you need to redact those out before you turn it over. That's totally normal to be done in every criminal and civil case. Connie, are they stalling? And to make sure that it's actually the right file. Sometimes they hand you a file that says this is John Smith's file and it may be Jane Smith. Are they stalling? I really don't think so. I think they really don't have it from the FBI. Callie, in your opinion, why would the defense ask for training records for these individuals? Is it to question their credibility or knowledge? If you want my guess is it is either to impeach them that they are not trained properly to do what they did in this case, or they did not follow their training, a la Scott Peterson or other cases where they leave something out of a police report and you go through and you say, you took this training class and it trains you how to write police reports and you're supposed to write everything important in your police reports, aren't you? When you interview a witness, you're supposed to do X, Y, and Z. Did you do that with this victim? You didn't. Why not? Did you feel bad for her? What happened? Why did you not ask the victim these questions before the interview started? Whatever the training is, if they did not follow the training, that's a big no-no. What is, Peter, please define training records, what training they took, classes they took, how long they've done things, what their knowledge is, what they're certified in. It can be a bunch of different ways from a bunch of different agencies. Chief Shenanigan Officer. What happens if 714 comes and the defense still hasn't gotten all the discovery they need? Well, now you can't ask for sanctions. Now you can say they are violating Kohberger's right to a speedy trial. You can get a continuance potentially without waiving your right to speedy trial because the delay is attributable to the state. Or the FBI has to provide a reason why they haven't turned it over. The state would have to provide that to the judge. Heather, are you going to do a Melly video today? If there's no Scott Peterson verdict, then maybe. If there is a Scott Peterson verdict, probably not. The Melly stuff at the end of the day every day has been tough. I've been tired and drained and still had stuff I had to finish after it. So the timing of it's been difficult, but I will keep doing Melly updates. It probably is not going to be every day right after trial, but I will continue to do Melly updates. Welcome, Kelly. Jory Johnson. Peter, why did they choose 10-2 just outside speedy trial? I think it's just inside the speedy trial. When they'll stall to see cards and trial will probably push back. Why choose that weird date? I think it was right before speedy trial, and it gave them a little bit of time where they could continue it once and still be within the speedy trial period.
The last officer did multiple interviews, I think a dozen or so. Many of them after the arrest of Mr. Kohberger. This officer also interviewed key witnesses in the case. This officer attended the autopsy proceedings. This officer followed up on tips. This officer made decisions about the tips that were given to law enforcement. And this officer also collected bits of evidence. Those functions that police officers make daily in their jobs, they make decisions about a case that later comes to court. They make decisions about the case the state's going to present against Mr. Kohberger. They talked to key witnesses. How they do their job, how they were trained to do their job, and what they relied on is incredibly important. When they take the stand, they will say, based on my training and experience, Idaho Criminal Rule 16 talks about witnesses. This is information that the defense needs to conduct its investigation and preparation.
Which is exactly the point, because officers are allowed to answer certain things or give opinions based on their training and experience. And if you can go back and dissect and say, you don't actually have training and experience that would give you the ability to make that opinion or make that statement, and then you have to impeach them with that. Well, you can't if you don't have it. So I think they should absolutely provide this if I was the judge.
And in response to that, you wanna,
Well,
I had a look, I thought maybe you wanted to say something else.
not necessarily, other than just to reiterate that this isn't covered by Rule 16, except for if the state were going to rely upon these witnesses and call them at trial, and then at that point, we would furnish all of that. Much of what Ms. Taylor is saying is just pure speculation.
You could say pure speculation, except she just had quite a list of what these particular officers were.
Boom. Wow. The judge is like, pure speculation, except she just had a list of all the reasons why she needs this, including that she may call them at trial. It's not pure speculation if you know they have connection to the case. And again, this is discovery. Discovery, not trial. I'm going to back it up just so everybody, in case you missed the judge say, speculation, except she just gave us a bunch of reasons.
Speculation.
You could say pure speculation, except she just had quite a list of what these particular officers were involved in the investigation. So, sort that out. Is that it with the motions to compel?
For today.
For today, of course. No motion.
Even the judge is a little surprised at how little they argued about today in the motions to compel, with all the motions to compel that we've been hearing, all the discovery that we've heard is going back and forth, asked for, objected to. I think even the judge is a little surprised. You have court time. Court time is precious. Now, this case seems to get it more than any other case. It's tough to get this many court appearances and hearing dates to argue in front of a judge in my cases. But even the judge is a little surprised, which may tell you they're working things out behind the scenes, which is good. That's what lawyers are supposed to try to do before they waste the judge's time.
From the state. All right. Okay. Well, I'm going to take this under advisement, look at the rules, look at some case law, and get a written decision. So with that, we're adjourned. Thank you all. Have a good rest of your day.
All right, so that's it. All right, let's get to the last few questions here before we sign off for the day. Crime, welcome, Dr. Bob and Desiree, all new members here before Friday's Members Only Live, always fun. Erica Lee, how is it speculation? I need help with that one. Well, what they're saying is, the defense is saying, well, we know that they interviewed some witnesses, they did this or that on the case, judge, and their training and experience may come into play. They may offer testimony that they say based on my training and experience. It may be important how they were trained and what they relied on. So you're technically speculating because you don't know for a fact that they are going to testify. You don't know for a fact they're going to say based on my training and experience. You don't know for a fact that the interviews that they did are going to play a part. So there is some bit of speculation there. The problem is this is discovery. And her points, Ms. Taylor's points, are absolutely appropriate for discovery. These are things that could lead to discoverable material. Therefore, they absolutely should be provided, in my opinion. She made points that could make them at least important to the case. That's all we're talking about here. It's not guilt or innocence. It's not this evidence is going to come in. That's not. It's just, could this help them in their defense and understanding? And it could be good. The officers could say, here's all of our training experience. It's great. And we did everything we were supposed to do, which would bolster the state's case. That's absolutely a possibility as well. Just because she's asking for it doesn't mean it's going to be good for the defense. Janet, do you think they would throw out the death penalty to save face? Not at this point. Do you think they would be making fools out of themselves by doing that if they had a weak case? I think the only way the death penalty goes away at this point is if there's some kind of plea deal. I think if this goes to trial, they're going to keep the death penalty on the table unless they balance it like they did in Murdoch and they think it's actually not worth it to go through the extra jury selection. It's not worth it to go through the extra penalty phase. It's not worth it to put that extra pressure on a jury knowing if you convict him, we're looking at the death penalty. And it's all going to be a moot point because they're so far behind on it in the state of Idaho that we know from other filings. Belinda, I'm starting to feel more and more that they may have done this, but has some bulletproof diabolical plan to get away with it as some sort of strange test for the legal system. Things that come out in trial may be shocking. I think the point is we don't know what's going to come out, but I think we can gain more confidence in the fact that Brian Kohberger and his team are not setting this up for leverage for a plea deal. I think they are providing a defense that he's either innocent or the state cannot prove that it was him. That's kind of where we thought it was going to be all along. This seems like more confirmation. I also think the state feels very confident in their evidence in this case. They are going to focus on cell phone, pings, car, Elantra, cameras, DNA. That's what they're going to do. There's going to be a lot of battle of the experts in this trial, no doubt about that. CH, question. Peter, how much does the state work with law enforcement once law enforcement has handed over the case information? I'm unsure what the process is from law enforcement doing an investigation and the state developing their case. A lot. They are the state's key witnesses. They help go through everything that happened in the case. They ruled out other potential defendants or suspects. So the state needs their help there. They prep them. They help prep other witnesses. They're their experts a lot of times. Law enforcement is the state's experts a lot of times. So they are intimately involved, especially the key officers and agents. Now, if you just signed off on a report or you set a perimeter somewhere, not a key officer, not going to be majorly involved in the case. But the key officers have serious involvement in the case, which is why it's good to deal with good law enforcement, because if you deal with the bad one, it really makes your life difficult as a prosecutor. Kathy, welcome to the membership crew. And Azam, thank you for the super sticker on our way out here. Indy 5 Gal. How can they explain the year change in the vehicle search? That's what the state wants to know. That's part of the process the state is trying to find out. And all of these things are so important to get answers, which is what discovery is fact finding. It's getting answers. It's broad and you narrow it into what actually comes in at trial. So that's what we're in the process of doing and seeking the truth and justice in this case. I appreciate everyone who's joined me. Hit that like button if you haven't already. Subscribe to our page. We are so close to 250K. It's going to be wild to get there on a channel that I basically would have been shocked if we got to 10K and was shocked when we got to 10K. So it's a testament to all of you. I appreciate you sticking around. Even those of you who disagree, I appreciate the dialogue. Always, I find it educational for myself as well. So that's all we got today. Make sure you check out our Scott Peterson jury question and verdict watch short video that's coming out this morning. And then we'll either have, some verdict discussion on Peterson or maybe a Melly video later today. Turn the notifications on, subscribe, do all those things so you don't miss out on any videos. Our schedule's kind of sporadic. It is what it is. I fit it in when I can in my real job, which if you want to find out more about that is coming here on the outro. Welcome, Christy. All right. See you guys next time. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law. is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.